Good afternoon, everyone. Welcome to the West Bend Mutual Insurance Investigating Workers' Compensation Claims webinar. It's our monthly webinar series for October 2020. Today, I'm lucky to have Rob McGavr, Director of Workers' Compensation Claims, and Dave Nedham, Associate Vice President of Claims as well with us. They will be giving this presentation today. Hopefully you see that your handouts are available below the chat screen on your computer. And I'm now going to turn it over to Rob, who will begin today's webinar. If you have any questions, please chat those questions in the chat screen at the end of the day, at the end of the session. Thank you.
Thank you, Jason, for that introduction. As Jason said, my name is Rob McGavr. I'm the Director of Claims for the Argent Division of West Bend Mutual. And because I'm not allowed to handle any money, sharp objects, or webinars by myself, I am joined by Dave Nedham. As Jason said, he is the AVP of Workers' Comp Claims here at West Bend. And we are going to talk to you today about investigating workers' compensation claims. So let's get started. So why are claims investigations so important? Well, workers' compensation claim costs directly impact the insurance premium that your organization pays. And there are many factors that can lead to successful workers' comp claim outcomes. And they all start with a solid claims investigation. So today we're going to discuss topics like the importance of investigating claims, statements, witnesses, who saw what, pictures and video, and what else you can do to help in the investigation, subrogation. So if there's a third party that might be liable for the injury, how we handle those claims. Any uses for surveillance. And finally, the topic that is on everybody's mind these days, globally as well as in the work comp space, considerations for COVID-19 claims. So with that, I will turn it over to Mr. Nedham.
Okay, sorry about that, folks. This is Dave Nedham. We had some technical difficulties with my mic and my headphone. We're starting off with the purpose of the investigation. Of course, our goal is to pay the benefits that we owe. And to get to that, we need to ask a few questions at the onset of the claim. We want to make sure that the benefits that we're paying are, in fact, for the covered loss. We want to determine how much is owed and for how long it's owed. And of course, this all begins with the receipt of that first report of injury. And from there, the investigation goes on for the life of the claim. As long as that claim is open, as new information is received, it may or may not impact the outcome of the claim, but the investigation carries on.
So as Dave said, prompt reporting of claims is critical and integral to the overall workers' comp claims management process. What does prompt reporting do? It allows us to get the claim as soon as possible and handle it efficiently and effectively. So when a claim comes in the door, we're looking to get the person to medical treatment potentially right away. And in doing that, we hopefully can get the person to treat with a preferred provider, and one who hopefully understands workers' compensation and the importance of things like return to work and light duty.
So if a person is at work, we need to determine whether or not benefits for wage loss or medical treatment is owed. And of course, we want to be able to explain the process as soon as possible to the injured worker. This basically puts the injured worker at ease, and it can help assist with reducing our litigation costs. Explaining what benefits are owed is not an admission of liability at the onset of the claim. Obviously, new information can come in, as I mentioned before, throughout the life of the claim that could impact whether or not benefits are continued. But we can still explain what primary benefits would be owed, such as temporary total disability, temporary partial disability, and medical treatment. We want to set expectations right away with that injured worker, make sure they understand that after each doctor appointment, they should be returning their return to work slip to their supervisor. The supervisor needs to know, can that employee work? And if so, what are those restrictions? We also want to set an expectation with the injured worker at the onset that our objective is to get them back to pre-injury work status. And that is, again, reiterated to the injured worker after each follow-up visit.
So again, prompt reporting of claims. Prompt reporting allows for timely claims investigations. So it allows the claims adjuster to immediately investigate the facts of the incident. So he or she can obtain statements from the injured workers, obtain statements from you as the employer, any witnesses, and make sure that they're able to do this while the facts of the incident are fresh in their minds and before any stories change, and before any legal representation or litigation plays a role in the claim. Prompt reporting is also very important for timely third-party investigations. It gives us the time and the opportunity to secure evidence, to appropriately document any facts surrounding the claim involving the third party, so it's appropriate to make a recovery if possible. Prompt reporting is also important for timely notification to the state, especially when we're either trying to determine whether we're going to accept or deny the claim. So many states have requirements that claims be denied within a certain number of days from the date the employer is actually notified of an injury. So prompt reporting allows the adjuster to investigate the claim in a timely manner and make that compensability decision within those time parameters that are confirmed by the state. And with prompt reporting, even if claims are for notification only, it helps us ensure that we are not dinged or fined or penalized in any way for late reporting. So if the employer is responsible for the late reporting, you can in fact also be fined or penalized by the state. So again, keep in mind and why the prompt reporting of these claims are so important.
Statements are another critical element of the investigation. There's many reasons that statements provide value on a workers' comp claim investigation. I guess the first would be we're trying to capture the facts as the employee recalls it at a moment in time after the injury that's not going to deter from memory loss. There's other ways that we can obtain information from injured workers or co-workers, witnesses, but this statement is probably the most used for us. However, in certain jurisdictions, we do rely on depositions of injured workers, of employers, of doctors. They can be critical to the claim investigation. The challenge we would have with any deposition is they're generally captured long after the injury is reported. So the value is reduced. Therefore, the statement on the front end is always critical for us, even if we intend to take a statement down the road. The medical records are oftentimes a challenge for us to obtain. Sometimes we have to subpoena the medical records. So subpoena is an option for us as part of the document capturing process, and they are also considered a statement. It's essentially a written statement. It's the medical evidence. Police reports are also statements that we obtain. Police reports are used. We'll talk a little bit more about those when we discuss subrogation, but we're trying to determine whether or not there's any citations given. We want to know the identities of any incident, of any parties that were involved in the incident. This includes witnesses, the weather, road conditions. Those are critical to our investigation. And we also like to obtain the incident reports that our employers capture when the employee first reports the claim. And again, this goes back to validating, the facts of the loss. Are these documents consistent with one another?
So what about witnesses? Okay, when there's a witness involved in a workers' comp claim, what do we want to know from them? Well, we want to know, what do they see? What do they hear? What conversations were they having with the worker prior to the loss? What about after the loss? We want to confirm facts of the actual loss. So if you can identify a witness, try and do so right away. And again, for the same reasons we discussed earlier, You want to make sure you document or have them document what they saw, what they heard, any conversations they had right away so their memory doesn't escape them. The other thing to think about is we always talk about the credibility or the character of an injured worker and how that plays into a claims investigation. A lot of people don't always think about the credibility or character of the witnesses involved. So you need to ask yourself, and we need to ask these questions to the employer. Is the witness, are they a good friend of the injured worker? Are they a family member even? Or do they not get along with the injured employee at all? And they can't stand them and they've had a long-standing feud or something like that. That can certainly change facts and stories. So again, all good information to think about when you're documenting, talking to witnesses.
So to summarize the recorded statement and witness statements, why they're so important. Again, this is our opportunity to capture the information while it's still fresh in everyone's memory. As Rob mentioned, we do use these documents to assist in validating credibility, whether it's a witness or the injured worker or any other party involved. It's our opportunity to memorialize the facts. Memories fade, recollections of the events change. And they change to the benefit of certain parties sometimes. And the information is also very critical to the treating doctors or the independent medical exam doctors that we rely on to give us opinions whether or not the condition is work-related and or to the extent of the injury. So witness statements, employee statements, they're very, very important. If we can get this information early in the life of the claim, it kind of goes back to prompt reporting and capturing data or capturing the information before it fades.
So talking about capturing the moment, pictures and video, what can they do? Why are they important? So again, in this slide, we're talking about pictures and video that the employer can take, that the injured worker can take, not necessarily surveillance. We'll get to that later in the webinar. So with pictures and video, what are we trying to do? We're trying to memorialize the area where the person was injured, maybe the part that they were working with when they were injured, or maybe a machine that they were working on when the injury occurred. Okay. Pictures and videos can also help assist in determining the cause of the injury and the extent of the injury, as well as aid in any subrogation. And subrogation, again, we'll touch on later in the webinar. But again, if you can take a picture or a video of the place where a person was injured, or again, a part or a machine that they were working on, that helps serve as the eyes and or ears for the adjuster. It shows them where the person was injured. It gives them a better idea when they're trying to recreate the injury in their head. It can also help, and we'll talk about this in a little bit as well, determine not only nature and extent of injury, but whether the mechanism of injury actually fits. So again, take pictures and video if and when you can, and encourage the injured worker to do the same. So say you work with a trucking firm and you have a driver who maybe had a slip and fall. If they're able to, have them take a picture or video of the area where the injury happened. It can only help aid in our investigation.
And to follow up with capture the moment, memorializing the area, part, or machine that was involved in the loss. A lot of times we only have one opportunity to memorialize that in a photograph. The conditions change. Once they change, we may lose the opportunity to go back and try to recreate that. And if we do recreate it, we lose credibility because if we're looking at another party as a possible cause of the loss, they can say that we tampered with the image and or with the surrounding area. Again, memories fade. This goes back to the recorded statements. Memories fade. We can't recreate the pictures, so it's critical to get those on the front end. And the last area would be some of the lessons learned. You all learn lessons from sharing stories, but stories are supplemented with photographs. we do the same thing on our end. We share the stories with other customers. Hey, this happened. It could happen to you, but take a look at it. These are lessons learned. And we've shared these stories across many different lines of business, and it's helpful. Our goal is to drive down losses, and this is one way that we can do it.
So photos and videos, they can also assist in determining the cause of the injury, okay? It can help with the root cause analysis. So again, we're not just asking what happened, we're trying to get to the bottom of why it happened, how it happened, and determine if, in fact, that the cause of the injury is, in fact, work-related. Any video can also help with any ergonomic assessments. So if you are able to take video of the injured employee and what they're alleging caused the injury, how they stand, how they sit, how they work, say, on a manufacturing line, it can help a doctor or an ergonomist determine if that injury was able to actually occur based on the facts of how the injured worker said it in fact did. Again, and you can take these things back to your safety or loss control reps, and you can help them, they can help you, determine if a job is set up appropriately from an ergonomic standpoint to avoid any future injuries in that particular job. And finally, ergonomic assessments, they can be provided to treating doctors, physician advisors, IME doctors to address causation. So we can send, again, photos or videos of a particular job to a physician and can help us determine, again, is it possible that the alleged injury occurred as to how the injured worker says it did. So if you have somebody who claims that they have a shoulder injury from too much reaching or overhead work, things like that, but the video would show otherwise, a doctor can address that and help determine, again, if it's a claim that we would owe or one that we might be able to deny.
So in addition to assisting with cause of injury, photographs, video can assist with assessing the extent of the injury. And by that, we would focus on what video or photographs would supplement a job description or a job analysis that maybe you already have in place, which would include the frequency and weights involved with lifting and or bending. This information we oftentimes provide it to the treating doctor to say, hey, help us understand why you put these restrictions in place. Can you limit the restrictions now that you understand or get a better idea of what the job is? So photographs really help the doctor understand what it is the employee does day in and day out. And it helps minimize the embellishment of the severity or the frequency of certain lifting and or bending that's involved with their job. Photographs or video can also help along with the job analysis with return to work recommendations specific to the job versus function alone. And our goal is really to ask the doctor, what functional restrictions can this person do? Functional restrictions follow the employee 24/7. That's the idea. But sometimes the doctors still want to understand the job itself. So our primary goal is to get functional capabilities, but we know that the treating doctors don't always understand what the impact of functional restrictions are. So it does help to show them what the job duties are. And the video and the photographs can really supplement the job analysis.
And finally, photo and video are key sources of evidence in third-party claims for potential subrogation. So again, we're going to touch on subrogation a bit more in just a sec, but those photos worth 1,000 words. The videos, again, they can be priceless when it comes to documenting the potential source of an injury, especially in a third-party claim. So again, that's talking about maybe you're involved in a motor vehicle accident. Can anybody take pictures of the scene, the vehicles, so we can help determine if there is another at-fault party? can you take a picture or a video of the area where a person slipped and fell, again, to help us determine if somebody else might be liable and there might be another party that we can pursue recovery of payment from.
So what is subrogation and why is it important? Workers' comp is generally going to be first-party payor on any injury to your employees. Meaning, if the employee is injured in course and scope of their job, but it's the fault of somebody else, workers' comp pays the employee for their time off work and for medical treatment. However, that other party is still liable, and we can pursue that other party for all the benefits that we've had to pay to the injured worker. It allows the carrier to recoup the money on behalf of the injured worker. The states, it's kind of interesting, but all of the states that we work in have different rules around subrogation. Third-party distributions vary by state. So one state may allow us to recover 100% of the paid amount that we've issued for medical and indemnity, and another state may limit it to 70% and or put a cap on the total recoverable for workers' comp. And some injury types, there's no recovery allowed in certain states, for example, Michigan. So we have to understand the rules of the state, but it is our opportunity to recover the money that another party was responsible for. The concept of double indemnification is drilled into basically all claims folks, whether it's work comp, general liability, property. Double indemnification means an individual gets paid twice for the same injury. That is not acceptable. So with work comp being primary, we want to just make sure that the third party responsible party understands that our lien, the monies that we've paid, is recovered, and that they also don't double indemnify the injured party. The bottom line, it's the last bullet point. Ultimate burden is on the tortfeasor rather than the employer or carrier. It's really saying the responsible party pays for the loss, and you as the employer shouldn't be burdened with additional premiums as a result. So we have the opportunity to recover that.
So successful subrogation. What do we do? What are we looking for to have successful subrogation or recovery from a third party? Well, the first piece would be early recognition of subrogation. It's, again, going back to that initial investigation and figuring out the cause of the injury. You have to ask yourself or ask the injured employee, what caused this injury? And if anything from a third party, a person, a machine, a ladder, could be a number of things, was the cause of the injury, then you need to go back and ask yourself, would they be liable? And get any of that information over to your carrier as soon as possible. Okay, that also involves prompt action on subrogation. So once we identify there's a potential subrogation, we need to start putting at-fault parties on notice to make sure we don't miss any of our recovery rights. The other piece of prompt action, again, is preserving evidence. I've certainly handled a number of cases where there could have been potential subrogation, but an employer disposed of, say, a bad ladder, or I had a case once where a gentleman was using a blowtorch and it exploded in his hand. And instead of saving the torch so we could determine if there was something wrong with the torch, something maybe we could go back to the manufacturer on, they threw it away. And once they threw that away, they also threw away any chance we had at a potential recovery on that. We also want to be aggressive and determine if it's cost effective to pursue subrogation. So when I say that, what I'm referring to is if we are in litigation and we're talking to an attorney and they tell us it's going to cost $20,000 potentially in expenses to recover any money from the potential third party. And we may only have the opportunity to recover, say, $8,000 to $10,000. Well, obviously, then it's probably not cost effective at that point to spend almost double the money in pursuing subrogation as opposed to what you could actually recover. And again, these are all things that the adjuster should be walking the employer through. We also want to identify any roadblocks early that we might have to any potential recovery. So things like waivers. Do you have an agreement with any vendors you work with or customers that you will not pursue them for subrogation? If so, we need to know that. We need to know that so we don't waste any time or money trying to go after a party that's already protected.
So summarizing our subrogation investigations, this slide contains a lot of areas we've talked about. Statements, recordings, photographs. We know the importance of them. We're trying to capture the information early. As Rob just mentioned, preserving the evidence. This is very important to us. If a piece of equipment is thrown away, we lose that. We cannot go back to that manufacturer and say, your ladder was defective, and they'll say, what ladder? So that is very critical. So if you have an employee that's injured on the job because of a piece of equipment, preserve that evidence. The other piece about preserving evidence is spoilage of evidence. So chain of custody is a big deal with evidence. So making sure that you lock that up as soon as you can so that the manufacturer can say, well, you tampered with it after the injury happened. So preserving evidence is very, very important. Skipping down a little bit, Rob mentioned this as well, giving proper notice to the at-fault parties. And here's another interesting twist for giving notice. Some at-fault parties are required to receive notice sooner than others. For example, municipalities, state or federal governments, we have to give them notice sometimes within 45 days of a loss. Generally, it's 90 days. Other parties, it's 1 year to 2 years, the statute of limitation for that particular line of business. So giving proper notice is very important to pursuing our recovery rights. And engaging with subrogation counsel. So Rob mentioned sometimes pursuing these claims can be very, very costly. What will happen often is the injured party, the injured worker, will retain counsel. If that's the case, we call it ride the coattails of that attorney. They incur the expenses. Now we can negotiate with that party, that attorney, if we so choose, but we're not under any obligation to do so. But we let them do the legal legwork, and we're paying wage loss benefits or medical treatment, whatever the case may be, and we do have recovery rights.
So next up, let's talk surveillance. Okay, it's again a hot topic. It always comes up in claims, especially where we think we have somebody who might be dishonest. Why do we consider surveillance? Well, between 2011 and 2015, it was estimated that the insurance industry experienced $131 million in fraud. And so we consider surveillance in all kinds of different situations. Again, one, maybe we think we have somebody who's being dishonest with us. We have somebody who has work restrictions and they're preventing them from coming back to work, but we hear or see otherwise. Or maybe they have ongoing pain complaints or medical treatment with no clear objective findings. It's simply complaints of pain, complaints of not being able to return to their job. But what makes successful surveillance? It's most successful when we have a lead on the injured worker's activities that they may be doing outside of their work, or activities that they may be doing that exceed their functional restrictions. So what's key here is if you have any tips, any leads for the adjuster to consider surveillance, provide those to them. For example, the injured worker plays softball on Thursday nights the injured worker is moving this weekend. They're going on a family vacation. These are all important things to let the adjuster know, because then we can set up surveillance. But more importantly, we know where to set up the surveillance. We know when, what time, what day. Otherwise, we'll get 8 hours of video back from a private investigator of somebody's front door. And that's not effective from a financial standpoint, and it's not effective improving our case any further.
So what happens if surveillance shows an injured worker exceeding their functional restrictions? We've got many different avenues that we can pursue if this is the case. I would first like to say that if the functional restrictions are 75 pounds and they are seen carrying a bag of dog food, we're probably not going to have any success unless that bag of dog food weighs 100 pounds. But in addition to that, we'd probably want to see the person carrying that bag of dog food repeatedly throughout the day. So it's really, what are we capturing? What is it that this person is doing that is violating their functional restrictions, and for how much and for how long? So one of the things we can do is we can provide a copy of that surveillance video to the treating doctor and say, hey, help us understand why you've imposed these functional restrictions, because clearly the person is capable of doing more. That can work. We've done that. We can also give a copy of this surveillance video to our physician advisor and ask the physician advisor to contact the treating doctor to discuss the restrictions to help us understand. It may be a little less of a challenge, I guess, for the treating doctor to have this conversation with a physician advisor. We can also provide a copy to our independent medical exam doctor to address what are the restrictions and or extent of injury, now that you can see the person's functioning at a different level outside of work. And then the last thing we can do is we can provide a copy of the surveillance to a deputy or a judge if the case is in line for hearing. Or if we want to share with the plaintiff attorney, if there is a plaintiff attorney, that we have information that the person is exceeding their restrictions. Now, that wouldn't be us turning it over, but that is a way that we can use surveillance. And the goal is really to show that the person is exceeding their functional restrictions. And, you know, Rob mentioned the fraud across the United States. You know, this is a type of fraud. It's basically the person saying they can't do something at work, but they can do it outside of work. So that's I guess a form of malingering and or just embellishing on their function. So there's different ways we can use the information. It just depends on the case itself and whether or not there's litigation.
So let's talk the pros and cons of surveillance. So again, as we've mentioned a number of times before, picture and video can be worth 1,000 words. But treating doctors, they can change their position on causation or length of treatment after seeing a surveillance video. But again, it can be for the better or for worse. So you may capture an employee working outside of the restrictions. We send that video over to the treating physician and they may say, wow, you're right, this person's being dishonest with me. Maybe we'll discharge them at this point. Or maybe they won't agree to treat them anymore, again, because they're not being forthright with their injury or their complaints. But on the flip side, and I'll give a real life example, I was once handling a claim where a gentleman had a shoulder surgery and had ongoing complaints of pain, mostly subjective in nature though. Not much was, from an objective standpoint, was pointing to the fact that he shouldn't be healing just fine. We received a tip from the employer that this employee was going to be moving over the weekend. And the employer actually had addressed it with the employee. The employee told them, I'm going to hire movers because obviously with my shoulder, I can't be moving anything. Well, we assigned surveillance anyways, and sure enough, we caught the employee moving out of his apartment. in moving heavy furniture, boxes, beds, dressers, etc. We took that video, the treating doctor, to see if they would change their position on whether or not the employee could be released for full duty at that point. The treating doctor felt bad for the injured employee and told him about the video. And the injured worker told his doctor that, well, because we weren't paying him any benefits, that he had to move on his own because he couldn't afford to hire movers. And so the treating doctor did not discharge this employee. In fact, he actually wrote that what he saw in the video would not lead him to believe that he was embellishing about his injury at all. It was simply because of a financial restraint on the employee. So again, pros and cons to all of these. We can provide surveillance video to a subpoena or independent medical examiner to review to help us determine if somebody can work within the restrictions, again, if they should be discharged. And when it comes to administrative law judges, deputies, magistrates, it's important to remember that they rarely make decisions totally based on surveillance alone. So surveillance showing someone that's exceeding their functional restrictions, whether or not at work, it doesn't necessarily disprove an injury occurred at work. It might only address extent of the injury. So again, it's important to remember that deputies and judges a lot of times may feel bad for some of these individuals. You know, they may see surveillance of a person doing something outside of the restrictions, and the injured worker may tell them, well, I was just having a really good day that day. You should have saw me the next day. I really paid for it. And a judge a lot of times has a hard time making an injured worker pay for medical bills or treatment that they've already had, especially if you run into a case where maybe they don't have health insurance, again, or maybe they have financial struggles. They may put that burden on the insurance carrier to pay regardless of what your surveillance says. So again, it's always important to remember the pros and cons of surveillance.
COVID-19 and workers' compensation. This is not a topic that we were thinking about, 10 months ago, that's for sure. Historically, communicable diseases were not covered under workers' compensation. There was no jurisdictions out there that would say that ordinary diseases of life, like the flu and colds, would be covered under workers' comp. They're too hard to track. However, enter COVID-19. COVID-19 has really changed the rule on communicable diseases. So as you probably have heard, some states have and some states have not imposed temporary rules on their law around this type of an injury. And so they've identified rebuttable presumption as a theory that would allow the employee the right of benefits, and the insurance company or employer would have to prove that that condition did not come out of their work environment. So normally workers' comp, the injured party, and this is almost all jurisdictions across the country, the rule states that the employee has to prove that their condition arose out of and in the course of their job. So if they hurt their back at work, they basically have to show evidence, and normally that's medical support. In this case, a select group of states, for purposes of today, we'll just say that we're talking about Illinois, Minnesota, Michigan, Wisconsin. Missouri as well. There might be somebody on the phone from Missouri, but Missouri has imposed a rebuttable presumption rule as well. They're saying that if somebody has a COVID-19 and they claim benefits to their employer, the employer and or insurance company has to prove that the condition was not related to their employment. Most states have imposed this rebuttable presumption to jobs such as first responders, so that would be police, fire, medical, frontline workers, and then one state, Illinois, has adopted the rule for all essential workers, and this encompasses about 60% of all workers. It's pretty hard to come up with a type of employer that wouldn't be considered essential in Illinois.
So as Dave touched on, rebuttable presumption is what we're looking at. So it's the burden to prove that something is not work-related by the employer or the insurer. So obviously in this case, we're talking about the burden being on us to prove that COVID-19 is not work-related for an employee. And again, Dave touched on the states that have some of these temporary rules in place. So generally what we're talking about here is an employee must either test positive for COVID-19 or have a clinical diagnosis of COVID-19 from a doctor. So once they have either that positive test or that diagnosis, the second component is they have to claim to have been exposed to COVID-19 on the job, right, in the course and scope of their employment.
For the states that have not adopted the rebuttable presumption rule, or for the states that the rebuttable presumption rule has expired, and that would be Wisconsin. Wisconsin's rule has expired. The employee can file a claim for COVID benefit or COVID-19 pursuing benefits. The insurance company is then responsible for proving that the condition is not work-related. So what does that mean, really? We're really looking to decide, was there a source patient that the employee was in contact with for a period of time that would put them in risk for COVID-19? We also want to find out what is going on at home. Were they recently traveling? Is there anyone else in the house that has COVID-19 or also traveled? So just because the employee says it happened at work doesn't mean that it did happen at work. So it's also interesting looking at some of the CDC information and how that's morphed over the past several months. What is considered prolonged exposure? So that can vary, but certainly if somebody is living with somebody that's got COVID, that's going to be prolonged exposure. So as Rob mentioned too, we need medical provider support. So a doctor has to say that the condition arose out of in the course and scope of their job. And a lot of times doctors are pretty quick to say that it was, but without having that, the claim is not covered. We still need medical support. Now, sometimes that's a challenge with COVID because all we have is a positive test. There is no follow-up doctor. So that is going to be the investigation the adjuster is doing with the injured worker and with you, the employer. So we still, if there is a rebuttable presumption, we still have the right to dispute that. And certainly if there's facts that put that employee in line with somebody outside of work with a COVID-19, a positive COVID-19 test, then we're going to probably err on the side of that the condition is not work-related and issue a factual dispute.
Okay, so what to do if an employee reports that they have contracted COVID-19? What should you do? So regardless of what state you're in, make sure first and foremost you're following the state's quarantine guidelines to make sure that we prevent the spread, prevent any other possible claims for COVID-19 with other coworkers. And report a workers' compensation claim if the employee is also obviously claiming that they not only have COVID-19, but they contracted it at work. Okay, so again, just because there's a positive test, are they claiming that they contracted it at work? Especially nowadays where COVID cases are on the rise, businesses are opening up, people are more apt to be out and about. It seems there's a lot of other places that COVID can be contracted right now. And finally, there's no legal obligation, again, to assume an employee contracted COVID-19 at work, even if you have a positive source patient. And with that, we want to say thank you for your time and see if there are any questions.
There were a few questions texted in, and so I'll let Dave or Rob answer these. The first question is paying medical benefits an admittance of liability, of course, beyond any diagnostic test that would be required? I don't know which one of you wants that one.
This is Dave. So paying medical benefits is not an admission of liability. And again, this wouldn't necessarily matter if we're talking COVID or any other claim, because we mentioned this early on. The investigation occurs through the life of the claim. So as new information is received that would alter the facts of the claim, we can change our position on compensability. Where it becomes a challenge would be when we're dealing with Medicare. So when we have Medicare benefit, when somebody is a Medicare beneficiary and we have paid any kind of medical treatment, Medicare is more difficult to work with to explain that the payment was made in good faith, in mistake of fact, and we should not have paid it. They don't seem to care. So we have to be very careful. We want to make sure we're paying the benefits that we think are going to be owed, and certainly not pay those that we don't believe is owed.
Thank you, Dave. Have another question. In terms of late timeliness or late notification, what is generally considered late in terms of notification, either to a comp carrier or to a state board?
And this is Rob, and I can take that one. So what I always tell our insureds is try to get a claim and have the goal to be turning that claim in within 24 hours or less of being notified of the claim, but even taking that a step further and turning in that claim again as soon as you are notified, because again, the quicker that we can jump on that investigation, get through all the facts, the quicker we can determine whether or not it would be accepted or denied. Now, again, various jurisdictions have different time lengths as to when an investigation is due by, or when a first payment would be due by. So we have to make a determination a lot of times before that first payment might be due to avoid any penalties. We can, again, sometimes ask for extensions or things like that. But again, the rule of thumb, just to be safe, is get it in as soon as possible.
Thank you, Rob. Question number 3 here is, when ongoing or follow-up medical visits for a compensable work comp claim occur, when those visits are during work hours, must the employer or carrier pay for the time away from work, or can the employee be forced to utilize sick or personal leave? And I recognize it's going to depend upon state as well, specifically the state. This question came from the state of Illinois.
So this is Rob, and I can take that one again. So again, it varies on jurisdiction. A lot of times what we can recommend to an employer is, again, offer to either cover that time or offer additional hours to the employee to make up that time that they had to miss for an appointment. First and foremost, we always encourage employees to make appointments outside of work hours if possible. Of course, we understand that life happens, and sometimes we have occasions where that's just not possible. But again, we try and encourage folks to work around that as much as they can. So again, if you are willing to pay for the time to have the employee go to the doctor, that's fine. Again, also a good tip or trick we usually have is, say the person has to miss an hour and a half or so to go to an appointment, offer them an additional hour and a half of work that week to be able to make up that time.
Thanks, Rob. Question number 4 here is Iowa a rebuttable presumption state in terms of COVID-19?
So Iowa is not a rebuttable presumption state as far as COVID-19 goes. Iowa has probably been the quietest state from a legislative standpoint with trying to alter any kind of work comp laws around COVID. Shortly before the meeting, I was talking to a defense attorney in Iowa just to say, have you heard anything in the courts yet about any COVID disputes? And he said there's been nothing. It's been very, very quiet. So for any carriers that have denied any COVID-19 claims in Iowa, there's no one is trying to make case law over it. The state has not, what I would consider, overreacted and jumping into these rebuttable presumption rules. So I applaud Iowa.
Thanks, Dave. This is the question Dave's been waiting for. The question was asked, if we think there's a possibility that an employee contracted COVID at work, but they do not realize they could submit a work comp claim for this, should we ask the employee to call a workers' comp carrier?
Okay, well, I'm not laughing at the question because it's a serious question, but yeah, that is a very, very good question. In fact, I guess I don't know the answer. Rob mentioned earlier, that if the employee, again, the capital IF, if the employer reports to you that they believe their COVID-19 was contracted in the course and scope of their job, yes, you should report the claim. The defense attorneys that I talked to over the past 24 hours would be Wisconsin, Illinois, Iowa, and Minnesota. I'm sorry, Michigan. The state laws around those in those states do not require the employer to make any assumptions that somebody's condition, whether it's COVID-19 or a back strain or anything else, is work-related. The employee is responsible to report that as work-related, even in the states with rebuttable presumptions. The rebuttable presumption did not change the rule relative to should I or should I not report the claim. The employee should really tell you the condition occurred in the course and scope. Now, the reality is we've had many customers report claims where the employee didn't necessarily tell them to. That's fine. That's the employer's choice. We are not suggesting anyone do anything different. And Jason Schaffenbuhl and I have had conversations around what is the OSHA requirement. OSHA has, of course, not been silent on this topic. And their recommendation is that if someone presents with COVID-19, you can inquire if they believe they got, or where they believe they contracted this disease. And if they say it happened at work, then you can follow up with, where at work specifically. Again, OSHA and the work comp laws are not the same thing. They're different laws. From all that I read about OSHA, there is no, and Jason, you can correct me if I'm wrong, but I do not believe that OSHA is imposing any kind of penalties on this, we'll call it a temporary rule around COVID. But the states are not requiring, the states haven't changed their laws on the reporting of COVID-19 claims. If the employee reports it, you should report it to us. If the employee doesn't know that they should have reported it, the statute of limitation will apply. It's just like any other statute of limitation. So I know I didn't address the question exactly. I think the safe bet is to say that there's still a lot of gray around COVID-19 and workers' comp.
Thanks for that response, Dave. To Dave's point about OSHA record keeping, OSHA in their guidance is saying, look, all employers, if you have a COVID case and an employee says it's work-related, you need to do an investigation. And OSHA has indicated that they will issue citations and potentially penalties if the employer then doesn't follow through and do an adequate investigation of finding out how the employee felt that they got COVID-19, whether it was through work exposure, specifically what work exposure. The key here is that OSHA is not saying you have to go ask every employee that shows up in your work environment how they got COVID. It's once the employee alleges a work-related injury, like you would for any other record-keeping requirement, if they say it is a work-related COVID condition, then you have to do your questions and answers. And OSHA has provided some guidance above and beyond just, is it medical treatment beyond first aid, lost work time, those types of things. Have a few more questions here. The next question is if an insured has a worker with a minor cut and they, the employer or the insured, decides to pay out of pocket and the claim blows up, can the can we as the carrier deny taking over that claim?
Thanks for that question. The carrier cannot deny taking over that claim. Obviously, we caution anybody paying out of pocket for claims. One of the initial benefits right off the top of my head is, again, we have preferred provider networks. We have a medical billing vendor that we use. So we do typically get pretty significant discounts on medical bills. So that could certainly help save money right there by making sure that the claim gets turned in and that the claim is paid through your carrier. But again, if an injury occurred at work and if we get it, then whether we get it the next day or whether we get it after it was referred to as blowing up 3 months later, we still have to handle that claim. So we cannot deny a claim just because it wasn't turned into us right away or just because the employer was paying for it out of pocket.
Rob, that's a great answer. At the end of your answer, that really answers the next question. The next question here is an employee is saying they hurt their shoulder in July, and the first time we're notified of it is now is October. Can the company or can the carrier deny the claim because it's hard to investigate when it happened so long ago? And the answer to that's, of course, no, based upon what you said. But what are some tips or tricks that you can give to the employer to help in this situation, help the carrier in this situation better manage the claim?
So if somebody, again, waits a few months after the fact to report a claim, commonly, we hear as part of the investigation, well, I didn't know if it was work-related or not, or I just wanted to wait and see if it got better, and it didn't get better. And again, these are common things we hear. Sometimes seems accurate, the person's being honest, and other times not so much. So again, it's fact gathering as much as you can at that point, trying to determine the factors around the alleged injury. So does this person have prior shoulder injuries that we know of? Does this person, were they even working on the alleged date of the injury? We've certainly had that happen where somebody said, hey, I was working however many months back on July 18th, and you go back and check and they weren't even at work that day. And then we have to, again, do our investigation to see, are there any other hobbies or anything else? But really then it would also fall on potentially a medical provider to determine, again, if the facts surrounding the case and the actual injury itself could be related to work as the employee's injuring or as the employee is alleging. So again, those are always tough cases. They're frustrating cases for the employer, for the adjuster, because you just, you have to ask yourself, why didn't you say something earlier? But again, we do certainly proceed with caution when we get those cases, because that is definitely a red flag where you don't get it the claim turned in right away.
There was a follow-up added to that. In this situation being discussed with this late reporting of a shoulder injury, if an employee waives their medical treatment at the time of the injury, and let's say they did report it at the time and said they didn't want medical treatment, are they able to make a claim later on requesting medical treatment?
Typically, yes, they would be able to come back and still, indicate that they're not better. Again, to the most common, I don't want to call it an excuse necessarily, but reason that, they said they wanted to wait and see if it got better. It didn't get better. And so now they want to treat. Yes, it's not uncommon to see that. Again, we certainly proceed with caution in those claims because it is a red flag, but that does happen. I think all jurisdictions do have statute of limitations as well in regards to reporting claims. Are all, again, a little bit different from state to state. So if you have a question on whether or not somebody has exceeded the statute of limitations and be able to report a claim, definitely reach out to your adjuster and they can help you with that, because again, it varies from jurisdiction to jurisdiction. But I can tell you, I believe it's Iowa, I want to say, has a 90-day reporting requirement. for the statute. But again, the vast majority of the time when we use that as a defense, a lot of judges just throw it out. It doesn't really even matter to them, even despite the fact that that's right there in the statute. So
we have, if for any of you out there, we are getting close to the end of this. I only have one question that popped up. There is a significant delay between the time we talk and the time you hear us. So I'm asking if you have any questions, please chat them now. We did have one just come in, and I'm gonna change the wording on it because I think I know what the intent was. It says, how do you prevent a previous injury from becoming the employer's problem? I assume it's an employee that they've hired and they know that they may have a weak shoulder or something before. How does the employer prevent that shoulder from now becoming their problem as the new employer?
Sure. So again, great question, common question. When you hire an employee for workers' compensation purposes, you hire them as is how we refer it. So if you hire somebody with a bad back and the job itself is making that back problem worse. So and when I say worse, the job itself or something about the job is making that back condition worsen beyond its normal progression. Then again, workers' comp benefits certainly could be owed to that person. How do you prevent that? Again, well, some employers have physical limitation requirements, lifting requirements that you have to verify upon hire. Do the best you can to make sure that the job duties are conveyed to the employees appropriately, so they have a good understanding of what they're getting themselves into. Again, work with loss control staff, or if you have a safety person on board, making sure you're keeping things in line with things like lifting, ergonomics, because again, the best type of claim from a claim standpoint is the one that didn't occur. So whatever we can do from a prevention standpoint, that's always your best bet. So if there's a way that we can do lifting from a mechanical standpoint, as opposed to a person having to physically do it, or rotating jobs, things of that nature, those are all things that you can implement to, again, try and avoid having somebody with a bad knee, a bad shoulder, a bad back, and try and get that covered under workers' comp.
A question was asked related to this. It says our facility does a physical before we hire someone. If the employee passes the physical does note bad back and is seeking treatment, you can choose not to hire them without getting a lawsuit since they did not pass the physical for the job. So not a question as much as a statement. The real key here is it's a whole other issue, a whole legal issue of pre and post offer physicals, what's permitted, what's not permitted, and the scope of those physicals. And so it's really important to make sure you have the validated job demands, and that's true whether or not you choose to do physicals. But then once you start looking at the physical, medical tests can only be done post offer. Physical demands, my favorite example is an organization that used to transport delivered bottled water to the home. They made the employees pre-hire load and unload a truck because that is part of their regular job duties. But that's way more than we want to get into for this, because that's a whole other legal issue that runs into problems. I would ask if anybody has any questions, please text them. I want to thank everybody for your participation today. This webinar was recorded. Anybody that registered for the webinar will get an email most likely on Thursday, possibly Friday, with a link to the recording so you can replay that. Again, I want to thank everyone for your time. And next month, November, our webinar topic will be slips and fall prevention. With winter coming around, we know that's always a big driver of claims within our insureds. So I'm going to thank everybody. Not seeing any additional questions. Oh, that was a thank you, not a question. Thank you, everyone. Have a great day. Goodbye.